Good evening, ladies and gentlemen. Thank you all for coming out to our event tonight, despite the pouring rain. It's not often that we invite a lot of people to our office, but it's great to see all of you here. My name is Ryan Lee, and I am this year's internship coordinator for the New York division of CASE's Grassroots Internship Program. For the last 3 months, we've been doing hard but necessary work in cultivating a flourishing community of Asian Americans and Korean Americans here in New York City. That includes weekly voter registration drives, creating election guide pamphlets, and meeting elected officials in Washington, D.C., and in our upcoming town hall tomorrow. Around a month ago, our interns began to work on this particular evening's project, a showing of Chol Lee's trial, with a script graciously provided to us by Abney. It took our kids a few weeks, but by watching documentaries, reading articles, and practicing the script, they were able to get a clear sense of the importance of Chol Lee's story, as well as what its legacy means for the rest of us Asian Americans today. And we cannot be more excited than to share all of that with you today on this fine evening. So with that being said, please make yourselves comfortable, amusable, and ready to enjoy this trial reenactment from our very own CASE interns. It means a lot not only to our own organization, but also to these kids here who worked very hard to make this happen tonight. Thank you. 자, 한국말로도 하겠습니다. 안녕하세요. 시민참여센터 케이스에서 인턴십 코디네이터 역할을 맡게 된 라이언이라고 합니다. 비도 많이 내리는 날인데 이렇게 먼 길 와주셔서 감사합니다. 어느새 석 개월이란 시간 동안 저희 인턴들은 많은 일을 했는데요. 유권자 등록 캠페인부터 위안부 역사 리서치, 그리고 워싱턴 DC에서 의원분들을 만나기까지 저희 풀뿌리 인턴십에서 이렇게나 열심히 일해준 친구들을 이렇게 볼 수 있다니 제가 뿌듯할 수밖에 없네요. 오늘 밤 여러분께 보여드릴 연극도 그 많은 프로젝트 중에 하나입니다. 지난 한 달간 열심히 준비해왔던 1973년도 캘리포니아 이철수 재판 사건을 재현한 연극인데요. 아주 유명하고 저희 아시안 커뮤니티에 참 중요했던 사건이었죠. 그걸 저희 인턴들이 열심히 배우고 공부하고 이렇게 연극으로 재현했는데요. 오늘 밤 여러분이 진심으로 즐겨보셨으면 합니다. 아이들 사진 촬영, 비디오도 많이 해주시고요. 끝나고 나서도 박수 많이 부탁드리겠습니다. 감사합니다.
On June 3rd, 1973, about 7 p.m., a gunshot rang out on a crowded street in San Francisco, Chinatown. Yippee Tak, a Chinese man in his mid-30s, fell, face down. A younger man approached from behind, holding a gun. He leaned over and fired 2 more shots, one into the fallen man's back, and the second into his head. The shooter escaped into the crowd, tossing the gun away in an alley.
Tak died at the scene, the latest casualty in a series of Chinatown gang murders. 4 days later, on June 7, 1973, the police arrested Chol Lee, a 20-year-old Korean immigrant, for the murder. This was his reaction.
I was very much surprised as I had no knowledge of any murder. I knew it was just a misunderstanding that would quickly be cleared up. I had the simple-minded thought of a not guilty person. And so I took the murder charge against me very lightly. An innocent man getting hanged, that just did not happen.
Chol Lee's faith in the system was misplaced. He was convicted of first-degree murder and sentenced to life imprisonment. 4 years later, while serving his sentence, he fatally stabbed another inmate in a prison yard fight. Despite his claim of self-defense, Lee was convicted and, because of his prior murder conviction, sentenced to death.
A third-generation Japanese-American college student, an American-born Korean community organizer, and a Korean immigrant newspaper reporter questioned the fairness of the police investigation and judicial proceedings. This case became known as Alice in Chinatown murder case for its surreal twists and turns. The effort to free Chol Lee brought together a broad coalition of Asian Americans of different generations, ethnicities, and ideologies. This afternoon, using trial transcripts, other court records, and contemporaneous writings, including Lee's autobiography, we tell the story of Chol Lee and his fight for freedom.
Why was Chol Lee arrested for the Chinatown murder? How did he come to the attention of the authorities? It began a few days earlier when an acquaintance showed Lee a .357 Magnum. Lee had never handled a gun before, and he asked to borrow it. On June 1st, in his room in the Skyway Hotel, as he was showing the gun to his girlfriend, Lee fired it accidentally. The bullet went through a window and lodged in the wall of the building next door. The police came to investigate on June 2nd, the day before the Chinatown murder, and Lee told them that a friend had inadvertently fired a gun. They recovered the bullet and went away.
Yippee Talk had been involved with the Wa-Ching Chinatown gang, whose leader had been gunned down earlier in the year. Even as the death toll rose, Chinatown residents remained silent. The police were unable or unwilling to make any arrests. But after the June 3rd murder, the mayor of San Francisco demanded results. There had been close to 20 Chinatown gang murders that had gone unsolved in the prior few years. The pressure was on for an arrest and a conviction.
And so, on June 7th, 1973, the police came back to the hotel and arrested Chol Lee. He had in his possession the .35 Magnum loaded with 5 rounds of ammunition and a pouch containing 41 .38 caliber bullets. 4 days later, he was put into a lineup for the murder of Yippee Talk. 3 witnesses identified him as the shooter. A San Francisco criminologist also concluded that the bullet recovered from the wall across from Lee's hotel room was discharged by the gun used to kill Talk.
Because of all the publicity in San Francisco, the trial was moved to Sacramento before the Honorable Robert Cole of the Superior Court. The state of California was represented by James Lazar, Deputy District Attorney for the County of San Francisco. Lee had been represented by public defenders in San Francisco, but they were replaced by Hamilton Hintz, an attorney in private practice in Sacramento, just 2 months before the start of the trial. Trial commenced on June 3, 1974, and continued until June 19, 1974.
The prosecution's principal evidence was the testimony of 3 eyewitnesses who picked Chol Lee out of a lineup. Andy Mill, a member of the U.S. ski team visiting from Colorado. His friend, David Lennon, who worked for a ski equipment company. And John Huey, who was in the Navy and from Arizona.
Stepping off the curb, I heard what I thought was a firecracker. I looked up and saw a man slowly falling forward in the process of being shot 4 or 5 times. I saw the man who fired the shot. He was wearing a rustic, goldish-brown jacket. He ran down the street. He was a male Oriental, about 23 or 24 years old, with a slender build, about 5'10" tall. I could see his face. He's sitting right there.
I saw an individual with a pistol in his hand behind another individual. He was pulling the trigger of the pistol very clearly, and the gun went off. I was across the street. I saw the suspect for about 3 seconds. I saw the man's face. The face was in motion and distorted. I was frightened, and I was in flight for my own life. He was about 5'7" and 145 to 150 pounds. He's the gentleman right over there.
I heard 4 shots. My buddy said they were firecrackers, and I told him they weren't. I ran to the vicinity of the shots. I observed a man running towards me. I saw his face. He was a male, Oriental, wearing dull green dress slacks, a mustard-colored sports jacket, and somewhere about 5'6" to 5'8". I see the man in the courtroom today. That's him.
The testimony of the 3 witnesses raised several questions. To what extent is eyewitness identification testimony affected by race, culture, bias, and fear? Was the lineup conducted fairly and in a non-suggestive manner? The witnesses were white tourists who got a momentary glimpse of an Asian assailant on a crowded street in Chinatown as gunshots were fired and bystanders scrambled frantically. There were many Chinese witnesses on the scene, but none were called to testify at trial. And the 3 tourists had picked at least 5 Asian men out of mugbooks, yet only one of the 5, Chol Lee, was put into the lineup.
A fourth eyewitness, Lawrence Saunderson from North Dakota, was called by the defense. He testified that the assailant wore a gold jacket, was about 5'10", and did not have a mustache. He also viewed the lineup and picked out someone other than Chol Lee. Two other eyewitnesses who viewed the lineup also failed to pick out Chol Lee. They were not called to testify at trial.
The prosecution also introduced, over the defense's objection, the .357 Magnum and pouch of bullets that were in Chol Lee's possession when he was arrested. The gun could not have been the murder weapon, however, as ballistic evidence showed that the gun used to shoot the victim was a Smith & Wesson .38 caliber handgun recovered in Beckett Alley.
The arresting officer was San Francisco police officer William Johnston. His testimony provoked repeated outbursts by Lee.
Do you see the man you were looking for on June 7th here in the courtroom today?
Yes, he is the Chinese male sitting at the defense table with black hair, blue shirt.
What?
No objection was made by Hintz, even though the fact that Lee was Korean rather than Chinese was important on the issue of his supposed gang affiliation. Rather, the transcript notes that there is an unintelligible outburst by the defendant.
You're referring to the gentleman who just spoke up?
Yes.
May the record so reflect.
I'm tired of these people coming in and lying.
Mr. Lee, there are two ways to handle a jury trial, the easy way or the hard way. Just calm down.
Johnston testified that he handcuffed Lee and took Lee to his vehicle.
At the time you handcuffed him, did Mr. Lee say anything?
Yes, he said, "Go ahead and kill me. Go ahead and kill me. I would be better off." Those were his words.
Then what did he do?
I placed him in the back seat of my vehicle.
Did you advise Mr. Lee of his rights as he was in the back of the car?
Yes, I did.
No, he didn't. You didn't advise me of no rights.
Now wait a minute, Mr. Lee. I want to tell you this for your own good. I will not permit any disruptions in this courtroom.
I'm the person who has to go to prison. Nobody else, sir.
Just simmer down. I'm trying to help you for your own benefit.
If you're concerned about my benefit, release me.
The judge did not release him, and Chol Lee took the stand in his own defense. He provided some background information, offered an alibi, and denied that he had committed the murder.
Mr. Lee, where and when were you born?
Seoul, Korea, August 15th, 1952.
When did you first come to the United States?
November 1964.
Have you lived most of your life here in the San Francisco Bay Area?
Yes, sir, since I've been here.
Having been born in Seoul, Korea, are you of Korean descent and ancestry?
Yes, sir.
Prior to your arrest for this charge, what type of employment did you have?
I was a cook.
Where were you living at the time of your arrest?
438 Broadway, the Skyway Hotel.
How tall are you?
About 5'4".
At the time of your arrest, what was your approximate weight?
About 125.
I would like to direct your attention now to the evening of Sunday, June 3rd, 1973. Do you have any recollection of the events that day?
I was sleeping in, about between 7 and 7:30 that evening. I received a telephone call from Cassandra Owing, Sandy.
Who was she?
Just the person I was going with, my girlfriend.
Did you make plans to meet her later that night?
Yes, sir. She told me she was getting off work late that night, told me to come up and pick her up. I was there about maybe 9:30 or 10 o'clock.
Lee testified that eventually he and Sandy wound back up at his room, where they spent the night. They returned the next night, the night of June 4th, and Sandy was still there the morning of June 5th when they got into an argument. They made so much noise that the landlady came twice, asking them to quiet down. The second time, she said that she had to call the police. Lee was concerned.
What did you do?
After she leave, if the police come, I had the gun there in my room, and I don't want to be found with a gun, so I go too.
You took the gun and the bullets with you when you left?
Yes, sir.
The following day, did you call the landlady and have a conversation with her?
Yes, sir. I apologized, and she told me to move out.
You've heard the name mentioned in this courtroom, Yip Yi Tak, as describing the name and identity of the dead man. Did you know that man?
No, sir.
Did you ever see that man before to your knowledge?
No, sir.
Did you appear on the southeast corner of the intersection of Pacific and Grant Avenue and shoot that man?
No, sir.
Did you own at the time a coat or a jacket that was gold or mustard or bronze in color?
No, sir.
With respect to these Chinese gangs, are you a member of the so-called Waching?
No, I'm not.
Did you ever take a contract to hit or kill the deceased in this case?
No, sir.
On cross-examination, Lazar emphasized that Lee had lied to police officers several times. He told them he didn't know Sandy's last name. He told them a friend fired the gun in his apartment. He told them he was not armed when he was. Lazar also portrayed Lee as a man fleeing from the police who rushed to escape with his gun and bullets. Lazar also drew connections between Lee and the other men in his lineup, suggesting an association with Chinatown gang members. Finally, Lazar highlighted Lee's familiarity with the scene of the murder, noting that Pacific and Grant was just a few blocks from Lee's apartment.
Although Lee's principal defense was an alibi, he was unable to call Sandy Owen. Hintz explained to the court, outside the presence of the jury,
Mr. Lee was represented by the Public Defender's Office in San Francisco for 10 months until I was appointed. The name of Sandra Owing was known to them, and she could have been contacted, subpoenaed, and brought in as a witness. That office dragged its feet. Now, I don't know what effort the district attorney has made to locate the witness, but I do understand they were too trying to find the Owing girl. Obviously, she could either confirm or repudiate the fact that she was with the defendant on the night of the killing, and this is highly important. Your Honor, I think he has had inadequate representation by his former counsel.
All right, Mr. Lasser?
Yes, Your Honor. We have run Sandy Owing through the Department of Motor Vehicles registration check, driver's license check, FBI, and a local rap sheet. We get no record of her in any of those places. We have attempted to check her at her home address and get no cooperation. But I would like to make the record very clear, Your Honor, this is not uncommon in any case involving Chinese youth gangs. We have witnesses who constantly duck our subpoenas, don't want to talk to us, avoid our inquiries. No matter how hard you strive for some people, they will not come forward.
On June 19, 1974, the jury returned its verdict. Judge William Gallagher took the verdict in Judge Chole's absence. The jury found Lee guilty of murder in the first degree and of use of a firearm during the commission of the murder. After the jury was dismissed, Lee stood up and spit at Deputy District Attorney Lasser.
You mother...
Let the record reflect that just shortly after the jury filed out, the defendant began to spit on the district attorney, and he began to yell profanities at him and became uncontrollable and had to be restrained. Is there anything you want to say in that regard, Mr. Hintz?
It is true.
Mr. Lee, try to restrain yourself.
Restrained for what, sir?
You'll be given a chance.
What chance will I be given for something I didn't do?
I'm going to continue the matter until Judge Cole is back here on July 10th for any motions that you want to make.
What motions do I have? I've already been found guilty, Your Honor.
When the parties appeared before Judge Cole, Hintz moved for a new trial based in part of the inadequacies of Lee's former defense attorneys. Judge Cole denied the motion, concluding that the evidence was overwhelming. Hintz filed a notice of appeal. The appeal was unsuccessful.
Cho-Soo Lee entered the California state prison system at a time when gang violence was, as he later put in his memoirs, out of control. The major gangs included Nuestra Familia, or NF, mostly Northern Californian Latinos, the Black Guerrilla Family, and the Aryan Brotherhood. At the time of Lee's arrival, the prison guards were on full alert in response to violence directed against them.
Lee was sent first to Dual Vocational Institution, or DVI, also known as Gladiator School, because of the violence and because it housed mainly younger convicts, 18 years and older. Within weeks of arrival, Lee was put in solitary confinement, in a lockup unit away from the general population. The lockup units, where Lee spent most of his prison time, were dominated by the gangs. He would later recall,
Each day, when yard time was over, we returned to our cells and dinner was sent to us there. Nights became my worst time. At night, I remembered I was an innocent man, convicted and imprisoned just for being Asian. What had I done wrong to receive such injustice? Why was the fact that I was Korean and not Chinese never taken into account? It seemed surreal. Meanwhile, every day I had to watch my every step, every word, and every action if I wanted to survive. My angry cry for justice was heard only by Ranko. She was my only outlet, as it seemed the rest of the world was blind. If I was ever to see justice prevail, even if it was a hopeless dream, I needed to keep a flicker of hope lit in my mind. The only other course was madness.
Ranko Yamada was the younger sister of a woman Chol Lee had dated briefly. When she read in the newspaper that he had been arrested, she was astonished.
The rest of the day I spent thinking about Chol over and over again. It added up wrong. I knew many people in Chinatown, many of the cliques and groupings of people my age, and had an idea of who associated with whom. Chol in a gang? Hardly. In Chinatown, he was called the Korean, a distinction at the time which pointed to being non-affiliated. Admittedly, I hardly knew him, but the situation didn't demand intimacy. The situation demanded that people not allow this kind of thing to happen. It demanded people to act and confront it. By the end of the day, I decided I wanted to be one of those people.
Ranko wrote Chol a short letter.
It was like a gift from heaven. Ranko wrote to say she was aware of my innocence and would try to help me in any way she could. She knew about the frame-up murder charge against me through her friends in Chinatown. It may have been a single spider silk thread, but Ranko's letter gave me enormous hope because I felt connected to someone on the outside who knew I was innocent, and this connection gave light to my darkness.
Ranko, a college student, tried to generate support among young people in the Bay Area. Tom Kim, a community organizer, also tried to build support. At first, they were not successful.
But in 1976, a reporter by the name of Kyungwon Lee attended a meeting with Tom Kim. The name Kyungwon means source of good news. K.W. Lee had won many awards for his investigative journalism while covering the difficulties facing African Americans in the Jim Crow South. He had joined the Sacramento Union newspaper in 1970. Years later, he recalled the meeting as follows.
Tom Kim was a third-generation Korean kid who started a community center in Chinatown. He said, "I feel really guilty about Chol Lee. The guy was railroaded." So he asked me, "Why don't you link into it?" And I thought at the time, wow, what is going on here? Here's this Korean kid, Chol Lee, and nobody knew, including myself. And that really hit me. I was an investigative reporter. I should have known. Koreans never think about people who are going to prison. Koreans don't give a damn. Remember, by 1976, I had been a reporter for over 20 years. So I looked in the mirror and I said, "Hey, this is your turn because I've been writing about the blacks in the South, risking my life. You know the name Chol is like David or Robert? It is a very common name. I have a nephew with the same name who is working on a PhD. And here's this kid. There's a razor-thin difference between them. I mean, those guys at UCLA, Berkeley, Harvard, they could have become like him. He had no protection. There was no shelter for him."
At first, the Sacramento Union would not let K.W. Lee do a story. Eventually, they agreed to let him investigate on his own time, and in June 1977, he set to work, initially without reaching out to Chol Lee. A few months later, everything changed.
Someone in prison administration had written a report identifying Lee as a Nuestra Familia member. Knowing that this could mean death at the hands of NF enemies, Lee filed a writ requesting that the report be removed from his file, and won. Nevertheless, the next time prison officials moved NF members, they moved Lee with them, locking him down with NF members until he appealed again, and won again. At that point, he was moved to L Wing, where whites who had recently attacked the NF with baseball bats were housed. As Lee later described it, the transfer was like giving raw meat to hungry lions.
Morrison Needham was an L Wing resident, a white biker with tattoos symbolizing white power. In the yard, Lee typically played chess on the border between the African American side and the white side. On October 8, 1977, when 7 whites moved toward Lee and the African American side of the yard, Lee was able to grab Needham's knife from his waistband and stab him. Many hours later, he was surprised to learn that Needham had died and that he would be facing the death penalty because of his prior first-degree murder conviction.
In Sacramento, K.W. Lee read about the fatal stabbing and realized it was time to approach Chol directly.
I wanted to convince myself that this was real. Then you know what happened? I read the story that he was charged with the second murder, so I had to see him because now the picture had changed. It was death, you see.
On December 1st, 1977, K.W. Lee met Chol Lee for the first time at DVI. At the end of the interview, Chol suggested that he contact Ranko Yamada for further information.
K.W. Lee's 2-part feature story on the Chinatown murder was published at the end of January 1978. The first story focused on Lee's life after his arrival in America at the age of 12. Unable to speak English and small for his age, he was bullied, beaten up, arrested, committed to the state mental hospital, and placed in foster home. He tried to commit suicide. In all those years, he never met a Korean interpreter or counselor or teacher. In the second article, K.W. Lee focused on what he called the nagging question.
This young Korean, who police suspected belonged to a Chinese gang, may have been railroaded in an unreal Alice in Chinatown murder case, where the deck was stacked against him in an ethnocentric system oblivious to the realities and experiences of Asian ethnic groups in California.
K.W. Lee cited a series of troubling issues, including the fact that Chol Lee was tried before an all-white jury and a white judge, prosecutor, and defense lawyer, and the concern that San Francisco police identification was highly suggestive.
The San Francisco police practice did little to dispel the old fear of Asian Californians who have been plagued by the so-called Orientals all look alike syndrome in criminal matters.
Reaction to the articles was immediate. Chol later recalled being placed in solitary confinement in a punishment cell and suggested to increased harassment by the prison guards. But at the same time, a movement was born.
The Chol Lee Defense Committee began at the home of Dr. Luke Kim and his wife, Grace Kim, in Davis, California. The Sacramento area had a small Korean population, and a handful of concerned Korean Americans met to form the committee. They were good people. J.U., who advocated for Koreans at a legal aid center, was elected to be the coordinator and started raising funds to support justice on my behalf through Korean church communities in Sacramento. Meanwhile, Ranko Yamada visited local colleges, and law students formed an Asian American wing in the Bay Area. Marking a significant moment in Asian American history, a joint struggle for justice brought together by foreign-born, first-generation Koreans in the United States with American-born Asians, forming a pan-Asian movement. It was truly miraculous that one Korean reporter who took interest was able, through his investigative articles, to awaken a great sense of justice in thousands of people on behalf of one Korean doing life in prison and facing the death penalty.
The first meetings of the committee were held in February 1978. In April of 1978, a lie detector test showed that Chol Lee was being truthful when he denied any involvement in the death of Yepi Tak. A new public defender, Leonard Tommen, was appointed to represent Chol, and on July 17, 1978, Tommen filed a habeas corpus petition seeking to invalidate his conviction for the Chinatown murder and strike the special circumstance that made the prison yard murder a death penalty case. Tommen filed the petition with the Superior Court for San Joaquin County, asking that it be heard before the prison yard murder case went to trial in the same court. Tommen cited as grounds ineffective assistance of counsel, the polygraph results, and the failure of the prosecution to turn over certain key documents, which suggested that shortly before the shooting, witnesses had seen the shooter exit a tan vehicle. Tommen found these documents when he was given discovery material. They had not been furnished to the San Francisco Public Defender or Hamilton Hintz.
On August 3, 1978, Judge Chris Pappas, the judge who would ultimately try the prison yard case, ordered the petition transferred to Sacramento County for review. No mention was made in the order of Tommen's request that the petition be heard before the prison yard case. In making his ruling, Judge Pappas commented as follows.
3 witnesses identified petitioner as the killer, and other witnesses who were nearby were unable to make the identification. It is a fact of life that when 2 or more persons witness a particular incident, they oftentimes will see it and tell it differently. This court has studiously reviewed petitioner's writ. Some of petitioner's contentions require extensive study and consideration. In the majority of the contentions, it appears that petitioner argues with commendable candor, but with the benefit of no or little authority.
Shortly after the petition was transferred to Sacramento County, the committee hired Leonard Weinglass to represent Chol Lee. Weinglass was the defense attorney who represented the Chicago 7 in their 1968 trial. He became the lead defense counsel for Chol and co-counsel with Tommen at the hearings on the habeas petition, which began on October 20, 1978, before Judge Lawrence Carlton. The prosecution was initially represented by Deputy District Attorney Kenneth Maleko for the County of Sacramento. On November 20, 1978, Weinglass recalled Inspector Frank Falzon, the lead detective in the original investigation.
Inspector Falzon, do you recall sending out an all-points bulletin on Monday, June 4th, with respect to the case of Chol Lee?
Yes, sir.
And do you recall I questioned you about that bulletin earlier in these proceedings?
You did.
Now, we questioned you about the portion of that bulletin which deals with the suspect possibly being connected to an automobile identified as a Cadillac or Coupe de Ville. Is that correct?
Yes, sir.
And what do you recall your testimony as being on this point?
I stated, I believe, it either came from a uniformed police officer or anonymous source to the police department.
Now, in connection to the bulletin, you also filed an affidavit with this court dated July 11th of 1978?
Yes, sir.
I want to place before you your affidavit, and I want to read from it and ask you if in fact this was your statement. Presently, I have no recollection regarding the source of the Cadillac information, and there's nothing in our file indicating the source of this information. My experience in cases in San Francisco's Chinatown tells me the information came from an anonymous phone call or a person who, because of fear, relayed the information in some anonymous fashion. Do you remember that in your declaration?
Yes, sir, I do.
And now before you wrote this declaration, you checked your file and found that there was nothing in your file that documented the Cadillac.
That is correct.
And you brought your file with you this morning, did you not, pursuant to the subpoena?
Yes, sir, I did.
And with the court's permission, may I examine that file?
You may.
Your Honor, may I be present?
Of course, he's doing it right here.
Oh yeah, right here in court.
It seems to be.
Mr. Weinglass, he'd like to be watching while you do this.
Certainly. My fingers will never leave my hand.
I can understand what counsel's doing here, but this is going to take all day if he's going to go through that file.
I think counsel knows exactly what he's looking for. Do you, Mr. Weinglass?
Yes, I do. While looking through, I can also be questioning you at the same time. Does the name Stephen Morris sound familiar to you?
Yes, sir. I believe he's one of the witnesses I interviewed.
Okay, and now, do the handwritten notes that you put together in connection with this case all appear in this file?
Yes, sir. To the best of my knowledge, they all should still be in there.
Although Falzon could remember the name Stephen Morris and the fact that a Cadillac was mentioned in the APB, there was no documentation regarding either in the file. Weinglass had 2 handwritten documents marked as exhibits and showed them to Falzon.
Let me show you what's been marked Exhibit U first, and I ask you if you can recognize a single-page document in handwriting.
Yeah, I can recognize the handwriting and the signature. Yes, sir.
So whose handwriting is that?
That would be Inspector Gus Carreras.
And that is dated June 4th of 73?
Yes.
Okay. Now referring to the top of the page, what do you see?
Went to Chinatown for dinner. Pacific Avenue.
And then what's the next item?
Time between 7 and 7:30. Tan-colored El Dorado or Coupe de Ville. Oriental male standing next to building off of Washington Street.
Okay. Let's hold it there. Now, is that document in your file?
No, sir, it is not.
And does that document, after reading it, relate to this case?
Yes, sir. This explains the reason my teletype was put out for a 72, 73 vintage, light tan colored, good condition. Is the wordage right there from my teletype. When I stated it had been from a police officer, obviously, it was Gus Carreras.
All right, fine. But this document indicates that on June 4th of 73, Gus received some sort of information relative to the Cadillac. Is that correct?
That is correct, sir. From a Stephen Morris.
Now, can you explain to the court why that document is not in the file?
There is no possible way I can explain that, counsel. The case file has left my hands on multiple accounts, on several occasions. Why that document was pulled, I cannot state, unless, possibly, it was introduced as evidence in the trial. That's the only explanation I can give.
Well, you can take my representation that it was not. Aside from that one exception, you have no explanation?
No, sir, I do not.
Okay. Now let's look at Exhibit T, which is a single-page document. First, is that your handwriting?
That is my handwriting.
Was that handwritten note in your file?
No, sir. I don't believe that was ever a part of the case file at any time.
Right. Now, having seen that in your own hand, does that refresh your recollection about Stephen Morris?
Tying the two documents together, you're probably correct, sir.
Do you recall if you invited Stephen Morris to the lineup?
I cannot recall.
Did you make an evaluation of him as a witness?
I must have. If he was not brought to the lineup, or there must have been reasons why he was not at the lineup.
Can you recall those reasons today?
No, I cannot.
Although Weinglass returned repeatedly to questions about the missing documents, Falzon could not explain why they were missing from the case file. Weinglass called Stephen Morris as his next witness.
Mr. Morris, directing your attention to June of 1973, do you recall being in the vicinity of Chinatown, San Francisco, where a shooting occurred?
Yes.
What time of day was it?
Around 7 in the evening.
Did you come alone?
Nope.
How many others were with you?
4.
And by what means did you arrive at Chinatown?
Car.
Now, do you recall where you went with the vehicle?
The corner of Washington and Kearny.
What happened to the vehicle when you got there?
We were going to pull into a parking space right there on the corner.
What happened next?
A car pulled in front of us, and there were 2 spaces to park in, and the car started to back into one of these spaces, so we bumped bumpers.
And what occurred at the point bumpers were touched?
I raised up out of my seat and looked, and a person in the back seat of the car turned around and looked into our car.
How would you describe that person?
Chinese.
Male or female?
Male.
Any idea of age?
Early 20s.
Could you describe the vehicle in any way?
Brand new.
And it was a small car, foreign car?
Large American car.
Do you recall the color of that car?
Tan with a black, either black or dark brown top. But it wasn't a convertible.
And how many people were in the car in front?
3.
Now, the one you described was the one in the back?
Yes.
Did you see the other 2?
Yes, there was a passenger and the driver.
Could you describe both of them to the court?
The driver was approximately 5'10", shoulder length, dark hair, black almost, with red highlights in it, parted in the middle, wearing a light jacket, brown pants, light blue shirt with paisley print. The other occupant was wearing a black quilted coat, black stovepipe pants, flat black shoes, cloth.
How tall was the other person, if you can recall?
5'8".
And the third person, what was his height?
5'8", close to.
Were all these people of Chinese descent?
Yes.
And where did you and the people you were with go, if anywhere?
We alighted from the car and decided to walk up Washington.
And then, where did you proceed?
To a bakery.
And where is the bakery situated?
Right on the corner of Grant and Pacific.
What did you do at the bakery?
We were looking at gigantic fortune cookies.
Gigantic fortune cookies?
Like that big.
What, if anything, occurred at that time?
I saw figures moving behind me with the sound of footsteps, and at that point I knew something was about to happen that would be quite... I don't know how to describe it.
Well, I'd ask this be struck as speculation, Your Honor.
You knew something was going to happen?
Well, I knew something was going to happen.
So what did you do?
I immediately turned around and pushed Shelley into the doorway of the bakery. At that point, there were 3 people in the street.
How far was the closest one from you?
Approximately 12 feet.
And did you see that person do anything?
Yes.
So what did you see him do?
Fire a pistol, a gun.
What did he look like?
Black quilted jacket, black stovepipe pants, black flat shoes.
Had you seen that person previous to that moment?
Yes.
When did you see that person?
Alighting from the car in front of us on Kearney.
And what happened after he fired the pistol?
The bullet struck the man in the middle and blood started pouring out. And then the 2 men took off and ran down Pacific Avenue.
Did you talk to the police that day?
No.
And the following day, what did you do in the morning?
Got up, made coffee, went down, bought the paper. I was working in San Francisco. I picked up the Chronicle just to read through it as usual, which I did every morning.
And did you see anything with respect to the shooting in the paper?
Yes, an article on the shooting and a small photo.
And upon reading that, what did you do, if anything?
Started feeling very funny, like I should do something.
Did you talk to anyone?
Yes, I called my mother.
And how old were you at this time?
20.
And did you discuss this with your mother?
Yes, I called the police approximately an hour and a half later.
Now, Mr. Morris, how far were you? How far from you was the person when he actually shot the pistol?
12 feet.
And how long did you look at that person?
30 to 50 seconds.
And do you have a recollection of what that person looked like?
Yes.
I ask you to look at the individual seated immediately to my left in the blue shirt. You're approximately 15 feet from him. Do you know whether this individual was the person who you saw fire the weapon on the corner of Grant and Pacific?
He is not.
Are you certain of that?
I'm positive.
And why would you say that?
Looks different.
Mr. Lee, would you stand up? How tall would you estimate him to be?
5'4".
And was the individual you saw do the shooting wearing any facial hair that you could see?
No.
And that individual's height?
5'8".
On January 19, 1979, Judge Carlton issued a decision concluding that the prosecution was in possession of substantial exculpatory evidence which it failed to provide the petitioner, and ordered that Lee be discharged from custody for the Chinatown murder.
The prosecution appealed to the Court of Appeal for the 3rd District. On March 21, 1980, the court affirmed unanimously, with Associate Judge Justice Peras writing as follows.
In the course of examining discovery files regarding the 1974 conviction, the 1977 defense attorneys learned of an all-points bulletin and the San Francisco Police Department interdepartmental memorandum, neither of which had been given to defense counsel in 1974. A petition for writ of habeas corpus was filed, alleging inter alia that the defendant was denied a fair trial by the prosecution's suppression of material evidence. During the course of the habeas hearings, defense investigators used the information contained in the memorandum, the bulletin, and other documents to locate one Stephen Morris, who reported to them that he had witnessed the shooting and the defendant was not the attacker. He so testified at the habeas corpus hearings and added emphatically that he had advised the San Francisco police by phone call the day after the killing that he was an eyewitness. At the conclusion of the hearings, the trial court found that Morris in fact told Carreras he was an eyewitness, and this crucial information was withheld from the defense to its prejudice. The people contend Morris's testimony was inherently improbable and unworthy of belief, irrespective of whether the testimony of Morris as to what he saw on June 3, 1973 is or is not inherently improbable. The defendant and his lawyers were still entitled to know of it so that they could judge that matter for themselves. The judgment is affirmed.
In the meantime, the prison yard murder trial commenced on January 15th, 1979 in the San Joaquin Superior Court in Stockton, despite efforts by the defense team to delay the trial pending the outcomes of the habeas proceeding. The writ of habeas corpus was issued on February 2nd, 1979 in the midst of the prison yard case. As a committee to free Chol Soo-lee complained in an editorial,
the prosecution was allowed to tell the jury that Chol Soo was a convicted murderer, yet Judge Pappas denied the defense request to tell the jury about the writ of habeas corpus. A prosecution witness from the talk trial was allowed to tell the jury that Chol Soo was the Chinatown killer. However, Stephen Morris was not allowed to testify to the contrary.
The courtroom was packed. There were young college students of Korean, Japanese, and Chinese descent. Many Korean elders also attended, drawn from churches and temples. Chol Soo-lee and the mostly Asian spectators were subjected to extraordinary security measures. Chol Soo was shackled at the beginning of the trial, and all spectators were searched and photographed before they could enter the courtroom.
On March 12, 1979, the jury returned its verdict, finding Chol Soo-lee guilty of first-degree murder. On March 22nd, the jury recommended the death penalty. On May 14, 1979, more than 3 months after the writ of habeas corpus had been granted, Judge Pappas imposed a sentence of death and ordered Chol Soo to be transferred to San Quentin to death row. As Chol Soo's supporters shouted, "Free Chol Soo! Free Chol Soo!" Guards gave each other high fives. Chol Soo was taken directly from the courthouse to San Quentin. His lawyers appealed his conviction.
A few months later, he wrote a poem about an inmate on death row who tried to commit suicide just before his execution. Here is an excerpt.
Who knows the man in the pale cell? Who knows what man is thinking in his last thoughts? Who hears this man's plea and prayer for life? Only the silence from God and people prevail. With midnight ticking too near to reality of execution, his life he tried to take in his last strength as man, with piece of broken glass from light bulb, his last stand of defiance against law for oppress.
The authorities hurried to execute the man, still bleeding profusely.
In late fall of 1981, J.U. visited Chol Soo on death row in San Quentin and told him that the Chol Soo-lee Defense Committee had run out of money to pay Wineglass's legal fees. The committee hired new attorneys for Lee in May of 1982 to prepare for the retrial. Tony Serra was a veteran defense attorney who stood close to 7 feet tall. Stuart Hanlon was less experienced but impressed Lee with his commitment. Law school students and recent graduates, including Ranko Yamada, helped as well.
As the trial day approached, an ad appeared in San Francisco papers listing hundreds of names of supporters demanding a fair trial for Chol Soo-lee. The presiding judge, the Honorable Robert L. Dosey, was asked to allow Lee supporters to rally in front of the courthouse. Over the objections of the prosecutor, the judge granted permission.
The retrial took place in August of 1982, with the verdict reached September 3, 1982. We have no transcript of the retrial, but we do have Chol Soo-lee's vivid recollections of what happened. He recalled the ballistics expert admitting that he was mistaken when he matched the bullet discharged from Lee's gun in his hotel room with the murder weapon. He could also recall Stuart Hanlon's cross-examination of the eyewitness, who Lee felt had taken the lead in insisting he was the shooter at the first trial. Lee had watched David Lennon testify twice before at the June 1974 trial and during the death penalty phase of the prison yard case in March of 1979. He remembered Lennon as someone who was working at San Francisco Juvenile Hall in August of 1969 when Lee was there, a fact that had not surfaced previously. Lee recalled that the witness left the courtroom looking visibly shaken.
At the retrial, the defense also presented new witnesses, a white woman and a Chinese man who who had been codenamed Witness X at the time of the habeas corpus hearings, but had refused to testify openly in court, fearing for his life. At the retrial, he testified about his fear, but was also clearly stated that he knew both the killer and Chol Soo-lee by sight, and that the man he saw run away after shooting Yippee Talk was not Chol Soo-lee.
In his memoir, Lee also recalled Tony Serra's final closing argument.
At first, he stood before the jury very tall, with his long hair combed back. But as his argument started to heat up, his hair started flying about. With emotion in his voice, he discredited all of the prosecution's witnesses and emphasized the difficulty of cross-racial suspect identification. As he spoke, he hammered his right arm down again and again, as if striking with an imaginary sword at the miscarriage of justice. He said, "Punish the prosecution!" He repeated, "Punish the prosecution!" throughout his hour-long, powerful closing argument. Each juror appeared to be paying attention to his every word. I sat and listened. Each time, Tony lowered the sword of justice and asked the jury to punish the prosecution. I felt the impact of his words. Stewart and Tony were finally bringing the truth of my case out in the open. That the San Francisco prosecutor had wronged me for all these years. For me, Tony Serra's closing argument was a highlight of the retrial.
The jury deliberated for 3 days. On the third day, it returned a verdict.
We, the jury, find the defendant Chol Soo-lee not guilty.
After a brief victory party at the county jail, Chol Soo-lee returned to San Quentin to await the outcome of his appeal of the prison yard conviction. Lee survived 2 more attempts on his life after his return to death row.
On January 14, 1983, the Third District Court of Appeal reversed the prison yard conviction in a 2-1 decision. Justice Coleman Blease wrote for the majority.
The trial court improperly instructed the jury and admitted a massive amount of hearsay testimony without guidance to the jury. After examining the entire cause, we thus believe there exists at least a reasonable probability that defendant might have been convicted of an offense less than first-degree murder in the absence of error. While the evidence of the defendant's guilt of first-degree murder was substantial, we, nevertheless, are of the opinion that there is a reasonable probability that a result more favorable to the defendant might have been reached in the absence of cumulative error.
On February 28, 1983, the California Supreme Court rejected the prosecution's appeal of the reversal. The prosecution moved to retry Chol Soo-lee on the first-degree murder charge. A month later, the Superior Court for San Joaquin County ordered that Chol Soo-lee be released on bail. His supporters had posted property worth twice the amount of the bail, which had been set at $250,000. Ronco's parents put up their home in Stockton. Buddhist monks put up their temple in San Francisco, and J.U. put up his house in Sacramento. Stuart Hanlon led Chol Soo-lee out the front door of the Stockton County Jail on March 28, 1983, to be greeted by a throng of supporters.
Chol Soo-lee eventually agreed to a lesser charge of second-degree murder without an admission of guilt in exchange for a sentence of time served. He had been in prison for 10 years. Finally, he was a free man.
Chol Soo spent his first day of freedom with Sojol Lee, a Buddhist monk at the temple put up as collateral for the bond.
I remember going to the beach with him, and he was happy, and he was screaming loudly to feel what it was like to be a free man.
But after that first euphoria faded, Lee struggled to adjust to life outside prison walls. As movement participants later recalled,
Most of us were so focused on freeing Chol Soo-lee that we didn't know what to do once we did it.
We were not prepared. When you've been incarcerated that long and when you grew up the way he grew up, you need a lot of love and support. And I don't think the movement was ready to the extent that he needed it.
Lee started using drugs and became addicted to cocaine. In 1990, he returned to prison to serve 18 months for drug possession. Then, in 1991, Lee and an accomplice attempted to burn down a house for the head of a crime triad as part of an attempted insurance scam. He slipped and fell on the gasoline-soaked floor and suffered third-degree burns over 90% of his body.
Charged with arson, he pled guilty and was sentenced to 3 years probation. When the triad leader failed to pay Lee the $25,000 promised for the job, he cooperated with federal authorities against him and spent several years in an FBI witness protection program.
On April 19, 2005, Professor Richard Kim interviewed Chol Soo and K.W. Lee in San Francisco. By then, Chol Soo had felt he had reached a turning point.
Coming out of prison at age of 30, I was like a baby. I thought I understood the normal ways of life, but I had no understanding whatsoever. I was brought out of a cage, and there was high expectation for me to do well in society, that I would somehow find a way to live a normal life. Unfortunately, I'm not blaming it on anyone, but I had no guardians, no one to guide me on how to live. I was totally lost in this normal world.
Over the next several years, as he spoke to Asian American Studies classes, provided guidance to at-risk youth, and advocated on behalf of the incarcerated Asian Americans, Lee worked on his prison memoirs, which, with the help of Professor Kim and others, were published in 2017 under the title Freedom Without Justice. Sadly, Lee did not live to see his work completed. He had undergone many surgeries related to the burns suffered in 1991, and finally, he refused further surgery and died on December 2, 2014, at the age of 62. He never received any apology or redress for the years spent in prison.
K.W. Lee left his newspaper, the Sacramento Union, to start Koreatown, the first Korean American newspaper to be published in English, and kept writing for decades. In 1992, from a hospital bed, he supervised his team as they reported on the Los Angeles riots and the tensions between the African American and the Korean American communities. He became known as the dean or godfather of Asian American journalism. The K.W. Lee Center for Leadership was the source for many of the photos you have seen this afternoon. Based in LA's Koreatown, the center works to give community youth the opportunity to develop into future leaders.
Chol Soo-lee's fight for freedom inspired many to action and generated much attention. In 1978, Bay Area musicians recorded a folk rock song, The Ballad of Chol Soo-lee, to raise funds for his defense. In 1982, the news program ABC 2020 aired an award-winning story, A Question of Justice. And in 1989, the movie True Believer, starring James Woods and Robert Downey Jr., was released, based on Chol Soo's case. But the movie, which was made without his knowledge or consent, ignored the role of the Asian American community and focused instead on the two defense lawyers.
Chol Soo-lee's story, his real story, still resonates today. The inherent problems with cross-racial eyewitness identification continue to plague the criminal justice system. There is still a need for support for at-risk youth, whether they be white, Black, Latino, Asian, immigrant, or non-immigrant. A need to turn prisons into something other than gladiator schools. A need for programs to help convicts make a success of their lives after release. The U.S. prison population has exploded in recent years to more than 2 million people, with some calling such mass incarceration the new Jim Crow. Under these circumstances, Chol Soo's story needs to be told today more than ever.
During his 2005 interview with Chol Soo-lee and K.W. Lee, Professor Richard Kim asked Chol Soo why is it important for people to know about his story. In response, Chol Soo expresses gratitude to all who helped him.
The greatest message that could be sent from the Chol Soo Lee movement is the purity, the unselfishness, the integrity of the people, giving to a stranger. And I think that needs to be brought back to the Asian community. I think we live in a world of selfishness. We have no room to share with others. I think if my story could be told, perhaps we could help make some room. The need today is far greater than in my own time.
Chol Soo Lee may not have fully appreciated the impact he had on the people who helped him. Many of the young activists behind the movement to free Chol Soo have continued along the path set in those days. Jeff Adachi was a college student and the bassist for the Ballad of Chol Soo Lee. He was elected public defender for San Francisco in 2002, a position he held until his death on February 22, 2019, at age 59. He was known as a fierce advocate for racial justice and a watchdog against police and prosecutorial misconduct. Warren Furutani, whose words we quoted as a supporter earlier in this presentation, became a California State Assemblyman. Grant Dinh, who biked from Seattle to San Francisco in 1981 to raise funds for Chol Soo's Defense Committee, worked in Bay Area nonprofit organizations for 30 years. And Ranko Yamada, who was perhaps the key to the entire movement, was inspired by the case to become a lawyer, as Ranko reflected at Chol Soo's memorial service.
There are so many times I thought he should have died, and he just kept on getting back up. That's what's so sad. He tried so hard. More than I would have expected from anyone. He just kept getting back up. He was one of the most important people in my life for so many years. He's a part of who I am and who my friends are. He helped shape my world.
All right, hello everybody. My name is Richard In. I'm the executive director here at CASE, Korean American Civic Empowerment. We're a nonprofit. We've been around since '96. We've been working on a lot of voter advocacy work along with other civic engagement stuff. So today, this was a trial reenactment. The script was made by Asian American Bar Association of New York, ABADI. And every year they make new scripts and they perform it live in front of an entire audience of thousands of attorneys at a national conference called NAPABA. So this is one of the scripts that was made back in 2018, and it was one of those scripts that was performed live. And when I was in law school, we put together trial reenactments just like this. And it's important for us to learn about these histories and ANHPI, impact events. And, a case like this, right? Because most of us, as Asian Americans, as Korean Americans, we don't really think too much about, the issues of mass incarceration, prosecutorial misconduct, or any of that. It doesn't seem to be an issue that we necessarily have to worry about. But having a case like this, a trial reenactment like this, helps us to reorient ourselves towards a more balanced outlook in terms of what justice is, how it should be carried out, and the importance of a diversification of a jury pool, of what a community can do when they come together and work together. And what can happen if the community stops working together too, right? They came together and helped Chol Soo get out of prison, but then once he was out, we saw what happened afterwards. He got into a life of drugs. Readjusting to life outside of prison is very, very difficult. And this is a situation where he was able to turn his life around and still had community support towards the end of his life. But that is not the story for a lot of folks that are going through the system today. And so today, I'm not up here to be preachy or anything, but it's more of asking us to consider what can we do as a community to help those, preventative measures so that people don't get into a situation where they have to face the criminal justice system. And what can we do as a community, not just the Korean community or the Asian community, but like just in general, like here in the United States. If you want more local here in New York City, what can we do to make rehabilitative efforts for those that are coming out of, being processed through the criminal justice system to readjust back to life and be reintegrated into society, right? Because there is that issue of, once people are out of prison or jails, they face this perpetual punishment system. They've served their time, but they're still punished for it later on, right? And I know that's a political topic and it can get heated, so I'll move on to the next. But it's something to consider on what can we do as a society to move forward to a better society, right? And I think the story of Chol Soo-lee touches on so many different aspects for us to think about and consider. And that's why it's important for us to do these kind of trial reenactments. Thank you, everybody, for coming to the first one. I think it went really well. We still have a lot of snacks, but before we get to the snacks and all the mingling, I want to bring the interns back onto the stage. So can you guys come back up and take a bow?